Hello, it's Katie Phang and Adam Klasfeld, and this is the reunion that has been long in the making. For those of you that have been hanging out with Adam and I pre our Substack days, Adam and I spent a lot of time together covering all things Trump, but especially the Trump trial. I wish we could have said plural, Adam, but we never quite got there. But it was just that
Great.
one. But I have the utmost respect for Adam. And one of the cool things that Adam has been doing as a part of his job, and also because it's an incredible service to our Substack community and to those that have followed, subscribe, and support Adam, is Adam, you've been actually going to the court hearings in the Kilmar Abrego Garcia cases. So why don't you get everybody up to speed in terms of what you've been doing in that regard? And why is it that you've been spending time in Maryland and in the state of Tennessee?
Thank you so much for that wonderful and kind introduction, Katie. The
Sure.
reason that I've been following this case is that it's about due process of law in the United States and where it stands. So the reason that I went to Maryland, that is where all of this began, when Kilmar Abrego Garcia and his wife, Jennifer Vasquez Sura, had filed, among other things, a habeas case in a civil lawsuit after the government spirited him, along with hundreds of other people, onto a plane to a dangerous prison in El Salvador, where Kilmar Abrego Garcia now has described his torture, an account that was corroborated in a news story, I believe today in the Washington Post. There were other testimonies from people who spent time at their prison in accounts closely mirroring Kilmar Abrego Garcia. And now that the government has brought him back, and now that the government has accused him of serious crimes, what was at issue today, what was uncertain and remains uncertain, frankly, is whether they will give him a chance to defend himself at trial. And what we have in back-to-back breaking rulings today, both in Maryland and in Nashville, Tennessee, are two judges who are saying, yes, Kilmar Abrego. In the Tennessee, the judges saying that the government has not met the legal standard to detain him before trial. He sent it back to the magistrate to formally release him. And once the magistrate does, another judge in Maryland said, yes, she has the power to make sure that there's minimum standards of due process, that the government can't once again take him into custody and send him to a third country, whether it's South Sudan, Honduras, the government won't say. But now, thanks to this judge's ruling, the government must allow him to be released back to his home state of Maryland, where his wife and children live, where he has been put on home detention as soon as his release order is active. And while the judge does not have the power to formally command the government not to try to deport him before trial, the judge does have the power to say you need to provide him notice, specifically 72 hours, 3 days notice. So Mr. Abrego can defend his rights, that his attorneys can argue against his deportation to a potentially dangerous war zone, as we've seen in other cases, and that we might actually see this trial that has been scheduled for January next year. So we've had this first test. Is due process in the United States still strong enough that the government must support the allegations they bring against a person they accuse of crimes? And so far, the legal system has passed that test.
Okay, so A, that's an amazing recitation. B, let's break it down. So
Right.
the very first case was filed in Maryland, and it was brought by Kilmar Abrego Garcia's wife, as you mentioned, on behalf of him, because he literally wasn't here in the United States, and on behalf
Right.
of their child. And it's because, as we know, in the violation process of the due process rights of Kilmar Abrego Garcia, he and others were basically kidnapped and taken to CCOT, that torture center in El Salvador.
Correct.
While that case was going back and forth, and by the way, it wasn't just Judge Zinnes who was commenting on it. We also have Judge Boasberg in DC that was kind of having his own say in what was happening. We then find out, obviously, despite the government saying that they could not bring him back, as in Kilmar Abrego Garcia, suddenly he gets indicted in Tennessee, of all places, in federal court. And because there was an indictment against him, he was then miraculously brought back to the United States from the place that the United States had said that they had no constructive custody over him and that they couldn't bring him back. So that's the reason why, Adam, we have two separate cases, right?
That's absolutely correct, and that's a perfect summary.
Okay. So while this has been going on, obviously Kilmar has not been able to freely have his liberty and be anywhere. So he's been held in custody in Tennessee. But a magistrate judge, which is a judge in the federal system that deals with certain issues kind of below, quote unquote, the district court judges, a magistrate judge conducted a series of hearings and ultimately determined that Kilmar Abrego Garcia could be released because the government didn't meet its standard to be able to hold him while his federal criminal case was pending, right?
That's right. And as a matter of fact, there were two judges who held separate hearings, and both of them gave deep insights into the origins of this investigation. We found out there was one government witness in both of these investigations, a Homeland Security investigations agent by the name of Peter Joseph. And both times, under cross-examination, we found out just what happened here, which was on April 28th. After the Supreme Court effectively puts the Trump administration on notice that they must bring him back, weeks after that, this investigation into Kilmar Abrego Garcia begins. And within weeks, they land an indictment. Well, what kind of rigor did they pass for that investigation? Well, we learn about a week ago, Sean Hecker from the same firm that won a multi-million-dollar judgment for E. Jean Carroll, Sean Hecker grills this agent and finds that, to take a step back here, there are two cooperating witnesses, both of whom are convicted felons, one of whom has been deported 5 times, and both of whom have entered into cooperation agreements with the government for both breaks on their criminal sentencing and deferred deportation. So deportation number 6 is pushed down the line for CC1, whose name is Jose Hernandez Reyes. Now, what emerged from the last hearing under cross-examination, blistering cross-examination, was that Mr. Hernandez Reyes spoke to other agents about 3 times before he spoke to Peter Joseph. Mr. Joseph, Agent Joseph, did not look at the notes of those meetings. It said that I wanted to go in fresh. Well, did you look at the notes after the meetings? Didn't look at the notes after the meetings. There's a picture that emerges that if these cooperating witnesses hear what the administration wants to hear, it's a go, too good to check. And what happens here is that within less than a month, it goes from a genesis of an investigation into a 2002 traffic stop, a traffic stop that hadn't been looked at for years, and it goes straight to indictment. And all the record suggests they don't really check what the witnesses are saying. These witnesses who have every incentive to try to get a sentencing break and to stay in the country after getting kicked out nearly half a dozen times.
So after this fulsome, very thorough evidentiary hearings are conducted, wherein the credibility of the witnesses is tested, these judges say the government doesn't meet the threshold that it has to meet legally to make sure that somebody like Kilmar Abrego Garcia must remain in custody while his criminal case is pending. That, and Adam, you know this because your followers and subscribers are like mine, right? Very much in the weeds for the legal, and we love to get there. That magistrate judge's findings, though, those are allowed to be reviewed if a party, objects to what those findings are. So the district court judge is allowed to check out those findings. And now you're saying today that the district court judge dealing with that in Tennessee said, I don't take any umbrage with what was found, and I support the idea that Kilmar Abrego Garcia does not have to remain in detention while his criminal case is pending. Is that right?
That's pretty much right. I mean, he reached it from a different place, but let me read just a little bit from his ruling because
Sure.
there have been a number of judges who have absolutely eviscerated the claims that Kilmar Abrego Garcia is a member of MS-13, and gang that the Trump administration has labeled a terrorist group. And from the judge's ruling, uh, nor does the government's poor attempts to tie Abrego to MS-13 get it there to the judges, to the government's burden. I'm reading ahead in the ruling. Based on the record before it, for the court to find that Abrego is a member or in affiliation with MS-13, it would have to make so many inferences from the government's proffered evidence in its favor that such a conclusion would border on fanciful. So this is just another judge who is blisteringly setting aside this claim that Kilmar Abrego Garcia is a member of MS-13. There have been judges in the civil cases saying, you presented me no evidence. Now, here's a judge who will be presiding over Kilmar Abrego Garcia's criminal trial saying the same thing, that the evidence would border on fanciful if he were to say that Kilmar Abrego Garcia is a member of MS-13. As a matter of fact, just one more quick thing.
Yeah, no.
The government's key witness, again, this Mr. Hernandez Reyes, who I mentioned earlier,
Yeah.
he's the top government witness, and his first interview with prosecutors was telling them that he didn't seem to have tattoos that would associate him with MS-13, just absolutely undermining the Trump administration's claims from the get-go.
And it's kind of sad, a reflection of the sad state of affairs that we're dealing with, Adam, is that Kilmar Abrego Garcia's team dealing with the case in Tennessee, the criminal case, opted for him to stay in custody in jail because there was a legitimate fear that if he were to be released and be walking out and about, that Trump ICE would come kidnap him again. And now, because you have all of these rulings from the Supreme Court, for example, that you can take people and just take them to third countries, without any notice, there was a legitimate fear. So this poor man has been in custody this whole time. And it's been waiting not only from this ultimate decision from the judge in Tennessee, but we also were waiting for this ruling from Judge Zinnes, because in his other case in Maryland, the civil case, with this order that we have today, it clearly says that once Kilmar Abrego Garcia is released from his federal custody in his criminal case in Tennessee, that the government is required to make sure that he is not only been brought back to Maryland now to be reunited with his family, as you say, on home detention, which also serves as a way to guarantee his appearance in court for his criminal case. But it also says that ICE is not allowed to take him into custody. But, of course, the deportation proceedings being separate, again, as you noted a few minutes ago, in the event they reinitiate that attempt to get him off of U.S. soil, it is 72 hours, business hours, which is not just 72 hours. It's business hours notice provided to not only Mr. Abrego Garcia, but his counsel of the intended third country, ostensibly, Adam, to give him the chance to fight. So now that we have everybody 100% caught up to speed, and this is especially because we have the amazing Adam Klasfeld here to walk us through everything that has been happening, that he's been witnessing firsthand as he works so tirelessly to make sure we know what's going on. Adam, let's deal with some of the comments that I've been receiving on my social media about this new news. Understandably, there is frustration from people. They have some celebration of how this is good news that we have rule of law and judges that believe in the rule of law, but frustration saying, well, is the administration really going to listen to these orders? As we've seen and witnessed, they haven't. Before I have you answer, I will read just 2 sentences from page 3 of the order that I will post in our Substacks, Adam. It's the first paragraph, and it says, defendants' defiance and foot dragging are, to be sure, the subject of a separate sanctions motion. And the judge references the actual docket number, the document that's relevant to this idea of sanctions. And then she goes on to write, the court will not recount this troubling history in detail, other than to note defendant's persistent lack of transparency with the tribunal adds to why further injunctive relief is warranted. Which means to me, Adam, Judge Zinnes is not only calling out the Trump administration, the attendant federal agencies for their noncompliance and basically their lies to the court, but she's basically saying, I was forced to enter this order barring you from doing something against Mr. Abrego Garcia because you guys are basically so full of shit that I can't trust that you guys are going to do the right thing. And my word's not you. You're definitely more elegant than me, Adam, in that regard. But your thoughts about some people that might be worried that we're going to have noncompliance on this?
That was the eloquent way to put it. I mean, it communicates Zinnis's palpable frustration. I was in that courtroom in the District of Maryland where that was happening in Greenbelt, and that passage that you just read, Katie, it just oozed with her palpable frustration when she was grilling these DOJ lawyers. She is angry. She is frustrated. She is indignant. She has been living with this case for months, and the Trump administration's uh, a flouting of court orders. I turn again to the Washington Post investigation recently, pointing out that they crunched the numbers, and in 1/3 of orders that have been filed, that have been ruled against the Trump administration, they're accused of flouting them. A handful of them have gone to potential sanctions hearings, sanctions motions. One of them is before Zinnis, but now we see a little bit more why Judge Zinnis is so angry. We've learned about the whistleblower report, Erez Ruveni. The whistleblower is the DOJ lawyer in this case who revealed what was going on behind the scenes, what Emile Bove was saying before he was getting ready for his nomination for a lifetime judgeship. This was in the Kilmar Abrego Garcia case. That's why folks like us have been following this so closely. So her indignation is very well earned.
Yeah, so let's shift gears to the next breaking news. And for those of you that want to continue to receive and know about this super deep dive that Adam is doing and that he's blessing us with right now, Adam, talk about how they can follow you. We're going to do it again at the end, but I want people to know the value of what you're doing. Where can they follow you and subscribe? Give them that information now before they don't get it.
Thank you so much, Katie. So you can find me at All Rise News. If you can, at the top left of your screen, there are links to both of our Substacks. I am on Substack as well. And your subscriptions will let you follow along the next time I'm in Nashville, Tennessee, or Maryland, or New York, where the site of the Epstein grand jury battle is taking place. So it's your subscriptions that allow me to keep providing this news on the ground and allows Katie to do her work. So you can find us both on Substack. And thank you for watching and supporting.
So let's talk about Jeffrey Epstein, because that's the other breaking news. So, very quickly, we now have a judge in Florida that has said, and this was predictable, I'm not going to unseal the grand jury transcripts. The government did not meet, frankly, any of the standards to be able to merit or justify me doing so. The only thing she did was say, I am officially closing the case number of the Jeffrey Epstein grand jury down here. I'm going to create a new case number just to be able to park the unsealing motion and my order. But that is in contrast, Adam, to the order that came out yesterday from Judge Paul Engelmayer, this is the order right here. And that is the Ghislaine Maxwell case. And in that instance, the judge did not summarily deny the motion to unseal that was filed by the DOJ. And in fact, he set a little bit of a briefing schedule and put the onus on the DOJ to be able to basically explain with specificity why any of the applicable legal factors have been met to unseal the Epstein file transcripts in this area, the Southern District of New York. But Adam, you got some breaking news for us too, don't you?
I do, and it's related to that topic that you just mentioned, Katie. Now, there were actually two federal judges who issued rulings just like that. It was Judge Engelmeyer and Judge Richard Berman. Judge
That's right.
Berman presided over the Epstein investigation and the beginning of the prosecution before Epstein turned up dead. Paul Engelmeyer is the judge who is replacing the trial judge who presided over Ghislaine Maxwell's case. Now, here's the very interesting part. If you read both of their orders side by side, they're
Hmm.
very similar. They're saying, as you mentioned, Katie, that the government hasn't even begun to satisfy the standard for grand jury. You need to do a lot better than that. Uh,
Yep.
but they also write this verbatim sentence: the government may not have notified the victims. So this is my scoop. I asked. I've been covering this beat for a long time, and I reached out to attorneys for the victims. And one attorney, Sigrid McCauley, who represented Virginia Giuffre, who represented Annie and Maria Farmer, and who represented hundreds of Epstein victims, gave me an on-the-record statement that yes, the government failed to inform the survivors of their recent move to unseal the grand jury information, that the survivors who brought this case to a head through litigation, through bravery, were left in the dark, according to an attorney for hundreds of them. So we ran the story, the exclusive, that Epstein victims were blindsided about the grand jury fight. And it's not just in one docket. It's not just the New York Jeffrey Epstein grand jury matter. It's the Ghislaine Maxwell grand jury matter. Before the Supreme Court has had the final word on the case, they're looking to unseal those grand jury records potentially. And they said, according to a footnote, they're going to try to do the same thing in southern Florida. So there are 3 grand jury fights. How many were Epstein survivors looped into? 0. They were left in the dark, just as they were infamously in 2007 when Jeffrey Epstein got the sweetheart deal. So this certainly, almost certainly, has bad memories for quite a number of Epstein survivors who have been left in the dark from the get-go, and in a tradition that remains to this day.
I'm so glad, Adam, that you brought up that sweetheart deal in state court for Jeffrey Epstein in Florida, because you're totally right. Part of the grounds for the litigation and the unsealing, that there was a limited amount of unsealing, was also an attempt for some of the victims to undo that plea deal that Epstein got, because they said we were entitled as a victim under the Victims' Rights Act to be able to be heard, and nobody told us that the deal was going down the way it did. And now we're hearing from an incredible lawyer who was one of the most spectacular advocates for the victims of Jeffrey Epstein that the government didn't even bother to reach out to find out what they cared about, which just goes to show how unbelievably selfish and self-serving, and simultaneously, I think it's sleight of hand, Adam. I've said it. It is almost predictably going to happen across the board. These records will not be unsealed. And it is a way by Trump to be able to blame the federal judges for their failure to, basically do what he thinks they should be doing, even though he really knows that legally it's not going to happen. But I'm so glad you brought this breaking news to everybody who's tuning in, because they need to know and they need to spread the information far and wide, because everybody will subscribe to All Rise News, that this is what's happening. They are trying to sit there and confuse and gaslight Americans into thinking that meeting with Ghislaine Maxwell, unsealing grand jury documents, etc., that all of this is normal, when the reality is it's not.
Right, right, absolutely. And the fact of the matter is, there are documents that are in the Trump administration's control that they have every ability to release. Grand jury minutes are not one of them. That includes a real hard legal fight, and I'm sure that the Trump administration knows it. I very recently interviewed Senator Ron Wyden, who
Yeah.
brought a giant investigation to the Trump administration's doorsteps about the money trail. He says it's a follow the money investigation. And he has new leads. He just sent out a letter today showing the leads that the Trump administration would follow. A serious investigation would look a lot more like that and less like Todd Blanche and Pam Bondi going by themselves to try to unseal grand jury minutes without the participation of the line prosecutors who got Ghislaine Maxwell convicted.
Oh, and then you've already mentioned there is a pending petition by Ghislaine Maxwell for the Supreme Court to take up her convictions and sentence. And so there's no way that those grand jury minutes are going to be unsealed in her case while that's going on. And frankly, absent her getting some version of a pardon, commutation, etc., she's not going to be trying to abandon her appeals either to be able to get some relief from the Supreme Court should they take up her appeal. And so, again, I find it to just be performative on the part of the Department of Justice. And from what you've now shared with us in your breaking news reporting, Adam, it's really an injustice to the victims of Epstein and Maxwell and others. I rely upon that phrase "and others," Adam, all the time when I talk about the Epstein cases and the Epstein files, because that's what the indictment said. The indictment said it was Epstein, Maxwell, and others that
Correct.
conspired to violate these poor girls in the way that they did. So I am grateful, Adam, for your intrepid reporting always. It is something that I have become accustomed to. And frankly, you spoil us, almost all 3,000 of us that are on right now, this live. Again, follow Adam Classfield for the latest. Literally, the guy is going to where the news is. Follow him at All Rise News. That's his Substack. He's also at Adam Classfeld, Klasfeld, on all of the social media platforms. Adam, as always, this has been a pleasure. I miss you, and I hope to see you in person soon.
I hope to see you in person soon as well. That was it. That was a wonderful reunion. We have to do it again more.
Absolutely. And thanks to all of you that have tuned in on your afternoon. I appreciate you. We'll see you guys soon.
See you soon. Bye bye.
Bye, guys.